Well, I'm off to the Privileges Committee now. This is a very important committee of Parliament that deals with allegations of breach of privilege and also questions of privilege, and so we're looking at the consequences of a decision of the Supreme Court in a case called Attorney General and Aaron Lee, and also a question of agreements on service of documents within the precincts of Parliament. I hold a number of responsibilities within government. One of the most interesting is as Attorney General. That is a very, very old office. I think it was first established in England in about the 13th century. The Attorney General has a number of very important functions. He or she is a politician, a member, normally a member of the Cabinet, but I'm also the law officer of the Crown. I have very serious responsibilities to ensure that the business of government is conducted in accordance with the rule of law. I'm responsible for the Parliamentary Counsel Office, which drafts the statutes, but I also have an important responsibility under Section 7 of the Bill of Rights Act. The Bill of Rights was introduced in New Zealand in 1990, and under Section 7 of that legislation, I have a responsibility to vet all bills that are introduced to the Parliament to ensure that they comply with the Bill of Rights. So what happens is that legislation is drafted and I receive copies of the bill. I'll also receive advice either from the Crown Law Office in relation to Ministry of Justice bills or the Ministry of Justice in relation to all other legislation, and they'll give me an indication about whether they think the bill complies with the Bill of Rights, and if it doesn't, in what respects it doesn't. Then I draw up my own conclusions and write a report. Now, some people may think that I simply tick off what's given to me by the officials, and they'd be completely and utterly wrong, because I take a very keen interest in these matters, and if necessary either draft my own report or substantially redraft what I've been given. I provided Section 7 reports on a number of public bills and also on a couple of members' bills that are shockers, like Holly Walker's ridiculous lobbying legislation, which seems to breach almost every provision of the Bill of Rights. But the important thing is that the Attorney General has not only to stand up to his enemies, or her enemies, but also stand up to his or her friends on occasion. I regret to say that over the years it hasn't always been observed how the disgraceful foreshore and seabed legislation avoided a Section 7 report simply beats me, and the Electoral Finance Bill, which was frankly a Stalinist piece of legislation introduced by Helen Clark in her third term to pay the National Party back for doing so well at the 2005 election, breached numerous provisions of the Bill of Rights, and yet it never received a Section 7 report. Sometimes, however, an early Bill of Rights report, which is circulated among colleagues, can cause the legislation itself to be amended. And there were a number of occasions last year when I said to one of my colleagues, well, look, I think this bill is going to attract a Section 7 report, and they've said, no, let's work together to see if we can make it Bill of Rights compliant. Yeah, this is the 19th floor of Bowen House, so as you can see, I look down on all of my colleagues in the Beehive. Don't put that in the film.